1 minute. So those then those allottees can go home with their monies, and we don't have to wait till after vacations. Item 44.
It is not taken up today.
If it doesn't reach today,
tomorrow.
Absolutely.
Not tomorrow, day after tomorrow.
Absolutely.
3 days we are here.
Oh, there's no difference. Then, of course, deeply grateful to your Lordship. Deeply grateful.
Your Lordship, I am in person, 44.2.
Achha. Please wait. We can touch 44 today. Looks a bit unlikely. But
that's why I mentioned, because there are several parted matters that your Lordship have.
other parted matters.
That's right. This will take 1 minute precisely.
If it is ultimately not even taken up tomorrow, we will keep it high on board on Thursday. So
we are vastly grateful, deeply. On the other side, Lord, also there.
Yes.
Four of the allottees he's representing. That's why, we don't want them to wait for 2 months. Grateful.
Right. Yes, column 26. 25. 25.
That's 47, section 47, madam, because they were to take some instructions that whether they are going to reinstate or...
Who is for the...
I have not been able to convince them to reinstate Malats, but
just refresh our memory.
He's 80 plus in any case.
He's 80 plus in any case.
He attained the age of superannuation on 1st of April. But anyway, he's superannuated, so he cannot be accommodated, even by my learned friends. So, Malats, the question is, Lordship will recall in this matter, my learned friend was invalidated out of service, pursuant to which he saying that he was 100% disabled. So the court said not only is he 100% disabled, so you give him the pension, but you also employ him, reinstate him and create a. Then the appellate court says you create a supernumerary post and you accommodate him. Now he'd never actually in the writ petition ever asked for this. He had genuinely gone and asked for that you give me whatever the requisite pension concerned, and I'm full 100% disabled. You give that to me, which wasn't. We denied it, saying that in terms of the records he was not entitled to it. But this employment came like out of the blue, and Lordship will recall we had contended. Now this service has now been taken out of the premises of the PWC. It was later. Yes.
Where is in the writ petition?
Yes. Where is in the writ petition? 67 Malats. It is therefore, Lordships are with me?
Yes.
It is therefore respectfully prayed that the may be pleased to issue writ, order or direction to the respondents that a petitioner may be granted 100%, granted invalid disability pension for 100% disability from the date of his discharge along with consequential benefits, interest of 18%, may be directed to constitute a fresh medical board for assessment of disability, may be declared null and void and illegal, and the entire record may be called at the cost of writ petition, any other writ or direction.
Where is the direction regarding reinstatement?
Well, that's in the single judgment. That's first starts off in the single judge. Judge is over there. Page 48 and 49. Single judge's order. Malas, the conclusion
125.
is
125.
123 onwards. 125. Yes. In all service, including annual increments, in the aforesaid observation, respectively, are quashed and set aside. Petitioner will be deemed to be in service into all annual increments. Well, the reason why he says this at page 123. Yes, I was right. Page 142. Sorry, the page before that. 122. That's the reasoning. Well, sometimes I remember page numbers and then I've written some other page. That's the last paragraph, and in light of the discussion, the action of the board in terminating service of disabled employee with effect must be in view of provisions of section 47 of the Act the appellant must be deemed to be in service, and he would be entitled to all service benefits, including
This annexure P2, annexure P6, annexure P9,
Yes.
which were quashed,
Yes.
there was no prayer to that effect. Please come to 125.
Please.
The High Court, the single judge, has quashed annexure P2,
Yes.
annexure P6,
Please.
annexure P9.
Please.
Where is the prayer in the writ petition for quashing of these memos?
68 lots. They refers to.
If you come to page 68,
Yes, please. Lots.
P1
P1 and P dash.
P dash.
We don't know what
P1 is not quashed.
P1 is not quashed.
What is P dash? We don't know.
Please.
So therefore, how could the single judge assume jurisdiction P2, P6, P9?
Page 106, my lords, where my lords, this honorable court's judgment was considered by the court, and section 47
Can
benefit
it
was
go
given.
beyond the prayers?
Look,
Can the court go beyond the prayers?
please do. They can't go beyond the place, my lords. But please, for a moment, have page 106.
Yes, we are on 106.
Their lordships of the Honorable Supreme Court in Kunal Singh versus so and so, while interpreting the provisions of section of the provision of the Act, held that even though a specific plea on the basis of section 47 was not taken before the court, still the Supreme Court had entertained a new.
So the High Court single judge feels that he is also akin to Supreme Court. Supreme Court has done this, so therefore I can also do it.
No, this is what Supreme Court held.
So this is what the purport of the order is.
Please.
A specific plea is not taken earlier, it's taken for the first time before the Supreme Court. It's a pure question of law, therefore I will consider it and I will quash memorandum which do not form part of the challenge. This is the order which has been upheld by the division bench.
Please. May I?
The reinstatement part we will not grant you.
Can I only submit this? Section 47. Lords, it is something which the law gave me. Consequential benefits, when I say, Lords, it is something which the law permitted me. 1998, Lords, the law came into force on 7th of February 96. I was invalidated, Lords, on 11th of March 1998. Persons with Disability Act.